We've heard the victim impact statements. Now we're going to hear some final words from the prosecution, and then we're going to hear from the judge. Let's go back into court.
Thank you, Your Honor. This case is about Corey, and the state would move for imposition of sentence.
So thank you. The record will reflect that the state played a PowerPoint type video presentation of approximately 3 or 4 minutes of certainly non-inflammatory pictures of Corey, many of them appearing to be when he was engaged in certain activities, others appearing to be perhaps some class pictures or school pictures. The court notes that that is specifically permitted under the Victim Rights Act, New Jersey Statute 52:4B-36.1 not only allows the survivors of a homicide victim to play to speak at sentencing, but also to present a photograph comprised of a still photograph, a computer-generated presentation, or a video presentation of the victim. And even there was no objection, I wanted to place on the record that that is what's occurred, and the pictures were all thoughtful presentations of Corey as a boy up to approximately 6 years of age. I'm going to make a series of findings and review some facts. I appreciate you had your client stand. When I get to pronouncing sentence, I'll ask him to stand again. So first, there's a pre-sentence report prepared in this matter which the court's required to consider. It confirms that defendant was found guilty by a jury verdict on May 31, 2024 of counts 1 and 2 in indictment 22-07-1332, count 1 being endangering the welfare of a child, a second-degree crime for events occurring on March 20, 2021, and count 2, the lesser included offense of aggravated manslaughter, a first-degree crime for events occurring on April 2nd, 2021. Defendant is now 32 years of age. He reported to the pre-sentence investigator that he's in poor physical health as a result of sports injuries, including a left ankle injury. Those injuries are not particularly relevant for sentencing. Defendant has been able to receive appropriate care in the Ocean County Jail, and the New Jersey Department of Corrections would be able to provide appropriate care for any such injuries. He reports being in good mental health. He graduated Monroe High School in 2010, and he attended various colleges, first in Connecticut and then transferring to various other locations, ultimately obtaining a Bachelor's of Science degree in psychology in 2015 from Ashford University. He thereafter continued his education, attending a master's program at Johns Hopkins University in Baltimore, where it's reported he obtained a master's degree in special education with a secondary degree or certification in mathematics in 2019. Part of the testimony at the trial was that the defendant was working as a teacher in a program for underprivileged or disabled children for approximately 4 years when he returned to New Jersey after learning that he was Corey's father. He has no military history. He's single. His only child was Corey, who's obviously the victim in this case. Thereafter, the defendant also had some employment in construction. He has a substance abuse history by his own report of alcohol and marijuana, which he describes as only socially, and prior cocaine use, which he describes as, quote, rarely.
All right, welcome to Law and Crime. The sentence is in the trial of Christopher Gregor. The judge has reached a sentence for manslaughter, the death of 6-year-old Corey Micciolo. We're going to go right into court now and hear that sentence.
It's generally considered inappropriate to find mitigating factor 8 or 9, but regardless, those factors are not present, period, for the reasons I've indicated. I agree with the position of the state and the victims that defendant was motivated by anger, that he took advantage of someone who couldn't resist, someone of tender years, incapable of resistance. The treadmill video demonstrates Corey's fear. Someone who does that, who has that disposition, is likely to reoffend. Therefore, 8 and 9 are not present. Although not argued, mitigating factor 11 is likewise not present based upon the defendant's injuries as reported in the pre-sentence report, for the reasons I've indicated, that the sports injuries and the left ankle injury can certainly be addressed by medical staff in any correctional facility, and If not, that correctional facility would transport the defendant to a hospital to be treated. So therefore, those do not overcome or even lessen the presumption of imprisonment. Based upon all the foregoing, then, I'm clearly convinced that the aggravating factors substantially outweigh the mitigating factors. So now I need to impose sentence, and then I'll address the state's request for whether the sentence should be consecutive or concurrent. I've appreciated that everyone has asked me to impose the maximum sentence. And I appreciate the emotion that's involved, the comments, and you've heard many of the things I just said about the treadmill video and the callous behavior. Imposing the maximum sentence is just legally unsustainable by me. There's no appellate court that would say someone with only a very, very minor criminal record should get the maximum. It just doesn't happen despite the public perception that it should happen. So on count 2, aggravated manslaughter, I sentenced the defendant to the custody of the Commissioner Department of Corrections for a term of 20 years, subject to the No Early Release Act, New Jersey Statute 2C:43-7.2, such that he has to serve 85% of that sentence before being eligible for parole. On count 1, endangering the welfare of a child, a second-degree crime, I sentenced the defendant to the custody of the Commissioner Department of Corrections for a term of 5 years. The defendant has 885 days of jail credit. So I have to address the requests for consecutive sentences. Again, there's a great deal of guidelines the court has to follow and a great deal of Supreme Court case law on this. The factors involve, first, the principle that there should be no free crimes. Secondly, whether or not the crimes and their objectives were predominantly independent of each other. Whether the crimes involved separate acts of violence or threats of violence, whether the crimes were committed at different times or separate places, rather than being committed so closely in time and place as to indicate a single period of aberrant behavior, whether the crimes involved multiple victims, and whether or not the sentences to be imposed are numerous, meaning multiple counts. Here we have 2 counts. With the proviso, again, that can be no double counting of aggravating factors. When there are multiple crimes involving multiple victims, the law is that the total impact of singular offenses against different victims will generally exceed the total impact on a single victim. We don't have that here. We have a single victim. But first, not to impose a consecutive sentence for the endangering would be to make that endangering offense a free crime. And one need only view the circumstances of the offense and the video to know it shouldn't be a free crime. The crimes are somewhat interrelated. They're not completely independent of each other, but they are predominantly independent of each other. Corey was subjected to an awful time on the treadmill that I've described. It was brutal to watch that treadmill video because you rarely see a child essentially inflict harm on himself in the beginning until his father starts to put him back on it. So it doesn't take a vivid imagination to consider the fear Corey's in at that point. The 2 incidents are approximately 12 or 13 days apart, although they both occur in Barnegat. They're at different times, and they are at separate places, although relatively close together, the gym at the complex and the defendant's apartment at the complex. But they're not so sufficiently close in time as to be a single episode of aberrant behavior. This is not someone that went and committed 4 car burglaries in a parking lot, one after another, which would be a single episode of aberrant behavior. They clearly involved separate acts of violence and or threats of violence and harm to Corey. The second act being the ultimate act, which was successful in ending his life. They don't involve multiple victims. So I conclude, for those reasons, that it would be to send a message to the public, to the defendant, and to those who abuse children, that you can get away with one offense if you get caught on the other, and that's simply inappropriate for deterrent reasons in general or for specific deterrence in this case. And therefore, I conclude that count 1 and 2 should be consecutive. The law requires me to make an additional statement on the overall fairness of a consecutive sentence. This is a requirement imposed by our Supreme Court in State versus Torres, 246, New Jersey, at page 246, a 2021 case, where our court held that the trial judges to make an explicit statement of fairness that explains the overall fairness of the consecutive sentence. So first, I've imposed sentence on the second-degree crime at the bottom of the second-degree range. Second-degree range is 5 years to 10 years. I conclude that if I were to go greater than the bottom of the second-degree range, I would be subject to an abuse of discretion as that being excessive. Secondly, the endangering sentence is not part of the No Early Release Act. It does not contain a court-imposed period of parole and eligibility. It's referred to as a flat sentence. Addition, the sentence is fair because of the reasons I just articulated about no free crimes. Defendant is 32 years of age. Absent some unusual medical event for a young person, he will eventually be released to his own liberty. He will eventually be a free man to walk around. Corey, of course, will not. So this is not the functional equivalent of a life sentence, despite the imposition of a consecutive sentence. It's also fair and just, given some of the testimony by Dr. Andrew, who testified in great detail about this, got down off the witness stand, went to the large screen TV and pointed out the bruising all over Corey's body, and testified about the injuries and bruising of different ages in different levels of healing, demonstrating the doctor's concern about ongoing abuse. We had pretrial hearings about this. The state in count 1, endangering, originally alleged abuse was occurring from December of 2020 through March of 2021, up through the date of Corey's death. I concluded that, really to protect the defendant's right to a fair trial, I concluded that many of the other incidents.
All right, sentencing is in on Christopher Gregor. Let me break this down for you. It's a 20-year sentence on aggravated manslaughter, that's the death of the child, and a 5-year sentence on endangering welfare, and that basically stems from the treadmill incident that we all saw the video of. The judge determined those need to be consecutive, meaning it's a 25-year total sentence. And under New Jersey's No Early Release Act, he's going to have to serve at least 85%, which I calculate to be 21.25 years before he's eligible for parole. He's 32 now, so he'll be at least 53 years old before he is eligible for parole. The judge said that the maximum sentence would not be sustainable on appeal, and it is apparent from his very judicious ruling, going through the factors and explaining his analysis, that he's trying to protect this decision from any attack on appeal. So legally speaking, it's a very sensible approach. As a father, I might think it's a little bit light. We'll be back with more trial news after this break.